Well, hello to everybody. Welcome to Gilligan Sheppard latest COVID-19 panel, where we discuss some of the topical issues around the present situation. Today we're going to cover commercial matters and insolvency, and in that regard we've got a special guest, Kalev Crossland from Shieff Angland lawyers. Kalev's heads the litigation team there, along with numerous other things I expect. And we've got our own esteemed Bruce Sheppard, which many of you, of course, will be familiar with. So just starting off, the first thing I want to talk about is the debt hibernation rules. Early April, we saw the government come out with this package, this new set of rules. So perhaps, Kalev, if you just want to start off and just explain to the viewers basically what these rules mean and
Sure.
And the practical impact, I suppose, on businesses.
Okay, Richard. Firstly, thank you for inviting me onto the panel, and hello to everybody out in lockdown world. I hope your lockdown's going reasonably well. I have to say, for me as a lawyer, it's absolutely fascinating time because you never see this rapid sort of change in legislation that we are seeing right at the moment. Included amongst that legislation change is the debt hibernation rules. Now, this is something absolutely brand new. Haven't seen it before. I'm unaware of anything like this anywhere else. Australia has been quite active and progressive in what they're doing, but they don't have this. So basically how debt hibernation works is, number one, you need to establish that you were a solvent company as at 31 December 2019. So the government doesn't want failing businesses that were failing for non-COVID-19 reasons to be taking advantage of the scheme. Second aspect of the scheme is it doesn't need anyone outside like an administrator or a receiver. You don't need to go off to court. All you need to do is put a proposal, and it's probably helpful to get that proposal organised by a firm of accountants and talk to these guys, Gilligan Sheppard. I'm sure they'll be able to help you. But the idea is you need 50% in value of your debts and 50% in number of your creditors to agree. So that proposal would be circulated amongst your creditors for their consideration. And it's probably a good idea to do some various different cash flow analysis, depending on like 80% of revenue or 60% of revenue. Now the beauty of just putting that proposal together is, whilst the creditors are considering it, you have a 1-month moratorium on any enforcement action. So even if it fails, you are buying yourself a 1-month breathing space. Now, if you are successful in getting 50% in value and number of creditors on board, then you get yourself a 6-month moratorium on any enforcement of debts against your company. And that may helpfully apply to commercial rent that may be owed over that period. You need to be satisfied, though, that you're going to be able to repay these debts after the moratorium's organised. So again, probably useful to have the help from some accountants to put all that together. So effectively, in a nutshell, you can buy yourself a 7-month moratorium potentially. Now that's, I think, going to be useful for any business in the current environment.
Do you know, sorry, Bruce, do you know if, so someone's already started action against you, does that like put a halt?
Yep.
On it?
Yeah, well, obviously you need to put it together.
Yes.
You can't just sit there and not take it, but it's really important that people are aware of this, and certainly for those of you who are listening to this today, you should pass this message on because it's really flexible, it should be cheap, and it's easier. You don't have to go to court like you do with other types of procedures under the Companies Act where your business is facing tough times.
Excellent. Bruce?
And it's also worth noting that in other arrangements, it is normally 75% by value and 50% by number. It's a hell of a lower threshold at 50-50. Kalev, I don't think it covers secured creditors.
That is, I'm not actually sure, to be honest. That's something that I would need to check. I suspect it won't. The difficulty we've got is the announcement that came out on the 3rd of April from the government did not actually specify that fact, and that's a point that's been discussed amongst lawyers. So you've raised a very good point.
Well, the omnibus bill came out, I think, last week, and I still couldn't ascertain whether secured creditors were carved out or carved in, but then I'm not particularly adept at reading parliamentary legislation in its draft form. But my understanding is a GSA holder can still exercise at this point their GSA. And I also thought that the interplay between landlords and this regime was also carved out, but that may not be so.
Yeah, I don't think landlords are, Bruce, but in terms of secured debt, let's just look at mortgages, for example, because on the one hand, and we're going to talk about this a bit later, I think, Richard, is if the tenants are getting some rent relief, well, obviously the flip side of that is the landlords are going to get pretty hungry, and many of those will need to pay their mortgagees. Now, what I can tell everybody is that the usual 10 working day period for when a mortgage goes into arrears under the Property Law Act as it currently stands, that is going to be extended to 30 working days. Okay, so effectively, that's almost 2 months extra, but it doesn't get us quite to that 7-month period.
No.
Australia,
the other observation I had, Kalev, is it isn't prescriptive on what your scheme of arrangement might be, right? So you give them notice that you are going into the debt hibernation. You do your plan. No one can enforce for 6 months. You have to be able to settle all debts. I don't even believe they put a date by which they need to be settled by, right? So it's not as if you even have to settle them through that 6-month period.
Oh, no, you don't have to settle it during the 6-month period. And again, we're scant on detail, but what I surmise is if we look at what's happening with the safe harbour changes, and that's something that we'll talk about shortly, they are talking there that directors can continue to trade even if they are currently insolvent, but one of the criterion is that the debts can be repaid within 18 months. So it may be that you can, when you
you may end up with a payment program over 18 months.
Yeah.
Now, I have also, just as a wild thought for people, you don't know what you don't know. So when you do your debt proposal, it is usually common to say, I will pay X amount per month pro rata, right?
Yeah.
It would now seem to me to be appropriate to actually pay X% of turnover pro rata, and that seems to me to be a permitted arrangement.
Yes. Yeah, well,
so you can effectively convert your debts from fixed commitments on your balance sheet to effectively cash flow obligations out of your revenue in this regime appears to me to be a plausible answer, so long as you have enough gross profit to actually break even net of those payments and satisfy the debts over whatever period of time you're projecting.
Yeah, I think that's a good way to tackle it, Bruce. And one thing that they've done in Australia, which I don't understand why it hasn't been done in New Zealand, is that they've got a mandatory code for commercial landlords and tenants, and it's got 14 principles. You can find this code, people listening out there, on the internet, but there's 14 principles under this mandatory code, and one of the principles is that the rent be adjusted based on a turnover basis. Now, it's, the government's done some quite good things with the debt hibernation and safe harbour, but why they haven't introduced what they've done in Australia to tackle commercial leases, I'm at a loss, because when you go to sell this debt hibernation proposal to your creditors, people are obviously going to be upset that they're going to be on the drip feed, but for directors or accountants like yourself that are assisting people with that, is you've got to say, well, to the creditors, what's your alternative? If you kick me out or you put my company into liquidation, who's your new customer? Who's your new tenant? Are there people lining up? So,
and by the way, whatever the number is you think I owe you will be recovered to a very different number. This plan at least gives you a swing at A, being fully repaid out of future revenue, and B, guarantees that I'll continue to be trading with you and giving you future cash flow.
Yeah, and
it is a darn good regime, but there's an awful lot of detail to be managed. And I think, Kalev, most people are thinking about debt hibernation as you said, an 18-month trade out.
Yeah.
I think you can actually do a debt hibernation where you project to pay people out over 18 months based on a percentage of forward revenue. And when you are 15 months into it, if you are off track, you do another.
Yeah, potentially. And I think the indications from government that these timeframes they're talking about could be fluid. From my perspective as a litigation lawyer, and I started shortly after the 1987 share market crashes. Well, if the creditor doesn't like it, what's your next alternative? Your next alternative is going to court. Now, what does that involve? That involves spending a truckload of money with the likes of me, and hey, I'll happily take that money. But what I'm going to be saying to creditor clients like that is, it's going to, at the moment, even once you file your documents, there's a backlog in the court. So typically we would get our documents back for service on the defendant within 5 working days. We filed stuff and we haven't seen it for 3 weeks. So there's already a delay there. Yeah. There's backlogs in court cases. So if you're going to do, say, an ordinary summary judgment on a guarantee of a lease or a loan, you're probably not going to get heard on a defended matter for about probably 10 months. You'll wait for 2 to 3 months for the judgment, and that takes you into, this time next year, all the while not being paid, and your defendant may have fallen over anyway. So, the money that you're going to spend, and this is probably a terrible advertisement, I'm doing myself out of business, but you to some large extent you are wasting your money on a litigation lawyer. You're better to work practically with your suppliers and your creditors and your landlords and your tenants. Everyone's got to pull together. That's the message we're getting from government, and I can tell you as a lawyer, that's the general vibe we're getting from the judges, right from the Chief Justice. It's all about getting on. We're being told as counsels, don't take picky points in your argument. Us as judges, we don't want to be, having to resolve silly arguments.
Yeah, interesting.
For all of our government sins, getting through this together is utterly the right answer. And that means negotiating fairly and honestly and with full transparency.
Yep.
And so long as we stick to those basic principles, we can avoid many of the pitfalls of dispute resolution that have been characteristic of the past.
Right. Well, we'll move on to the next. Sorry, Carl.
No, carry on. I was just prompting you for the next question. Bruce,
yeah.
Go on forever. Otherwise.
Yes. So you mentioned a couple of times, of course, this new safe harbour rule, which came out in the same announcements in early April. What's your, perhaps again, just explain a little bit about what that all means and what your thoughts are in terms of its potential impact on directors in terms of their governance and requirements and responsibilities.
Okay, so I think everyone out there should know, ought to know, that as a company director, a key obligation is that you do not trade the company's business in an insolvent fashion. So solvency are two matters: being able to pay your debts when they fall due, and secondly, that your assets exceed your liabilities. Now, that cardinal duty has been modified a bit in recognition of the current situation. So again, a little bit with the debt hibernation, you need to be able to satisfy, to take advantage of the safe harbours, you need to be able to demonstrate that as at 31 December 2019, your company was solvent. So that's the first thing. You then need to have a good faith belief that in incurring debts during this COVID period, you would be able to repay them in an 18-month period. So again, you want to, if someone was to challenge you on that further down the path, you want to be able to have some cash flow analysis that you might have an accountant assist you with, so that you're able to defend the position. So that's not a license to go out and buy that, Maserati or Porsche. It's the usual supplies or services that your business might require that you are going to be incurring. Now, what this means is that if in good faith you incur those, because after all you're trying to keep the business running, keeping employees employed, it doesn't work out, you are not going to be donged by a liquidator for reckless trading or insolvent trading if the company goes into liquidation. So again, it's the government giving legislative encouragement to business to keep going. Let's work together and get through this. There's a second aspect to this, perhaps a more technical aspect. If the company has received payments, let me start again. In the usual environment under current law, if you make payments as a company that later goes into liquidation to various suppliers, then a liquidator can go and review all those payments that have occurred in the last 2 years before liquidation and go and collect them up and then redistribute amongst all creditors. Now, what that's called is a avoidable transaction. Mm-hmm. That regime, the avoidable transaction regime, that is going to be suspended, so that if people receive payments from directors of companies that later go into insolvency and into liquidation, then those suppliers who've received those payments won't be susceptible to having those payments clawed back.
There's probably one caveat to that, Kalev. I believe that there is a carve out for related party transactions.
Yes, yeah, absolutely.
So you can't simply say, whoop-de-doo, I've suspended all my creditors in a scheme. I think I'll take the safe harbour and then strip the balance sheet to repay your shareholders' loan account.
Yep, good point.
So you've got to be careful about related party transactions.
Yeah.
I'm not sure whether when I looked at the bill and I looked at the Schedule of Companies Act amendments, they haven't inserted a definition of related party, which is interesting. So I think you should probably assume that a related party will be a related party for the purposes of the Income Tax Act, which means if you have another company that is supplying your company and you're a more than 25% shareholder, you want to be cautious, because that may be avoidable.
There's a definition, Bruce, of related party in the Companies Act, and I would.
Okay, cool.
that is what it's going to apply. But basically, if it's, a family member or a spouse or a related company,
is that 25% in the Companies Act as well?
I would need to check that.
Yeah. Anyway, just be cautious where you have an interest in a transaction. Now, a couple of evidential things that are probably important beyond cash flows. When you are in a vulnerable period in a company's trading, and whether you're in a safe harbour or you are potentially trading while insolvent, the thing that will save your bacon are documents. And documents are evidence of board processes. So in many private companies, you don't have board meetings, right? If you do, they're oral and they're often undocumented. If you go into a safe harbour regime, at the very beginning of it, you need to have comprehensive board papers that demonstrate that A, you were solvent as at December, that the board rigorously considered that and concluded that they were solvent. You can't just do a document. The board, because it's the board that is seeking protection under this, has to show that as a board, they have considered that they are eligible for entry. And then if you want to cover yourself during a period of that safe harbour while you are trading, and let's assume you're not trading well, you need to have continuous board oversight and monitoring to understand exactly what you're doing prudently.
And Bruce, that would include probably weekly cash flow analysis, wouldn't it?
It would include, it's all the basics, right? But the thing that people do is they do the basics, Kalev, and then they'll have a meeting at around the lunchroom table and review it and not document it.
Mm-hmm.
They absolutely have to document not just what they are doing as executives, but what they are doing as a board, acting as a board.
I also think recourse to professional advice is important, because already under our existing law, a director does have a defence if he or she has acted in good faith based on professional advice. So I think that's particularly important to run a lot of this stuff past your accountant.
So what happens then is you run it past the accountant. You will now need to insist on a self-serving report. That report becomes a board paper. The board objectively and critically reviews it, because you can rely on advice, but you can't rely on advice blindly. Right? You are expected as a director to behave as a prudent person of business, which means you're obligated to look at this and say, does this advice resonate with us? And then you pass a resolution saying we accept the advice and in reliance upon it we are doing X. But it's going to be, I think, really important, Kalev, if people are using this regime, that they actually get their governance, grossly overused word these days, properly documented, because absent that, they won't have the evidence that they need to beat off a cordamenta.
Yeah, and you need to stick with the discipline of that throughout this period. It's not just the first 3 or 4 weeks. It's
for the entire period.
Yeah.
There is a good product out there. I'll give a plug for a product, acknowledging I'm A, a shareholder, and B, a director of it. There is a great product called Board Pro, which automates action points, minute taking, agenda setting, and document repository.
Yeah.
Now, as a portal for aggregating that data as an evidence pool, it's easily searchable. You can edit minutes. It doesn't leave audit trails. You can document after the event, but only to a point until the minutes are finalized. But it is you need to come up with a process of ensuring that the board, as a board, has discharged its obligations. And that is often a weakness in private companies. They do all the right things, they don't write it down.
I think that the other thing that directors would need to do to safely sit in their safe harbours is to acquaint themselves with all the various assistance available out there. I think everyone knows about the wage subsidy scheme. But secondly, talk to your bank, see if you can get yourself onto interest only, or even an interest holiday, and likewise talking to your,
and putting that in your minutes that you've applied for it, and reporting back on it and managing it as an action point, all shows the behaviours that you're behaving prudently.
And I think also negotiation with IRD for payment plans as well. They're pretty amenable to that at the moment, aren't they, Richard?
Very much so, yes. Yeah. And very, very prompt too.
Yeah.
But generally only for 6 months, isn't it, Richard?
I think the 6 month thing is where you pretty much get an immediate response. What we found, I think, if you're stretching out to 9, 12, maybe longer months, then that's where they may come back and say, look, we need a bit more data from you.
Just one other thing, just to drop in there, guys, is, we've all sort of focused on the survival. Now, for some, this actually may be too hard, and if you're not sort of hooked in with big bank guarantees, or you can satisfy your bank, sometimes it may actually be better just to fold up shop, literally hibernate and come out and start a fresh business later. That is an option.
Hard decision to make, but I've done it in the past with tax debt, because the people just don't want to let go of their companies, but the tax debt's just so onerous, and for whatever reason the ID is not forthcoming with any sort of hardship relief or that sort of thing. So
well, I think we've even seen in the professional services arena, there's examples of business where they've just said, nah, we've had enough, and they've shut up shop. So don't be too prideful about that.
That's right.
I can tell you that after the 87 share market crash, numerous people went bankrupt, and it wasn't such a stigma. People understood that going through that time, and particularly, if you're under 45, you can restart. There's also the ability to seek early discharge from bankruptcy. I'm familiar with the legal principles around that. So,
and there is a belief that there is a stigma attached to it, right? And yes, there may be in some quarters, but as I say to most people that come to me and say, what are the consequences of this? What will my credit rating be like? I always say to them, I am yet to see a money lender that won't lend money to someone who doesn't need it.
Right. Moving on to perhaps a more commercial matter, therefore, away from the insolvency issues. Obviously, with the reduction to level 3 a couple of weeks ago, we saw a lot more firms being able to open the workplaces, provided they were deemed to be what's called safe workplaces. It's going to, again, I've sort of briefly read the level 2 provisions as they come out, being released today, in terms of what things will look like under level 2, and the expectation is basically all workplaces will be open perhaps from as early as next week. With this, of course, though, still comes this requirement around safe workplaces and the social distancing thing, which has been reduced down to the sort of the 1 metre area around yourselves. Do you see any sort of, or what do you see as the impacts on health and safety requirements for employers as a result of that, Kalev, and potential exposures, I guess?
We've got a highly contagious virus out there, and cross fingers, touch wood, etc. We've escaped that, but if we haven't, and you as a business owner or even a general manager, there are high levels of personal liability for getting it wrong. So you need to be absolutely careful in putting a program in, and it needs to be a documented program, and that's going to be particularly applicable to those businesses working in high-rise buildings where we've got this logistical issue of the use of lifts, so pushing the button and then cramming in. So that's going to be a big headache for the commercial lessors, but also the businesses working within those buildings, because as employers, you've got an obligation to keep a safe workplace. So, if we get a run of, transmission of the virus, and there's information out there about how to do it, and it can be demonstrated that, you failed to have this hand sanitizer, you failed to have a written policy in place for physical distancing within your office, or maybe, having only a few people coming in, you're putting a target on your head. So
that's a good point there. Just think of that. So if you are in a high rise, at what point does your employer become liable? Say I walk in the revolving doors downstairs, am I on premises at that point, or is it actually when I walk, say, on the 37th floor into the office? When does the employer...
As a litigation lawyer, you want to sort of sue everybody. So you would probably target the commercial lessor, the owner of the building, but also the business that you're visiting.
Mm.
So it's not only employees, but it's also
customers or suppliers, couriers, anything.
We're taking that a step further, Kalev, assuming that we have tracing up and running, which I'm sure we will. Even if they aren't microchipping us, they'll find some other way. Let's assume that the source of infection is a business on the 15th floor that your employee picked up in the lift on the way to the 37th floor. When you're suing the employer and the building owner, I presume you might end up joining the business on the 15th floor as well.
Oh, yeah. No, there's...
if not every occupant in the building.
Yeah, well, to give you another example, there were the bit of media around some fast food, national fast food joints where people were desperately crowding up for their burgers. Now, all of those people, if they were to spread the virus or to result in New Zealand business going back to level 3 or level 4, and it could be traced back to one of those places, there's a massive class action there,
Oh, it just gets more and more fun.
Yeah. So, I don't know if you know any litigation funders out there, Bruce, but
funnily enough, I do.
That's something I'd be keeping my eye on.
Yeah, that's a very good idea.
So just in terms of that advice, are you
for that business?
Are you having clients ask you, if, and it may be too early yet, but if we go to level 2 next week, should we tell our staff to go back to work, or should we just, try and keep them home? Yeah.
Well, I haven't been. It's come up in conversation because there's obviously a lot of issues that we're being asked about. Restructure, redundancy, commercial leases, construction contracts that have been. We're getting everything, but that topic has come up. So it's really a matter of common sense that if you can still work from home, do so. And in fact, I don't know about you guys, but I've actually been quite enjoying it. Avoiding the traffic. So
yeah, me too. Yeah.
This isn't just a legal issue, but it's a business issue. It's what are the opportunities actually out there for doing business differently? The fact that we're actually having this panel discussion now is testament to that.
Yeah, agreed. Right. Well, the last question I've got on my list anyway is I understand there's within most ADLS commercial lease agreements, there's this clause 27.5 that talks about rent reductions in emergency situations. Perhaps if you could just talk a bit about that, Kalev, and how you've seen it in operation or expected to work in operation, because I think it talks about a fair reduction or something, and of course both parties are going to have a view in terms of what's fair.
Absolutely. 27.5 has created numerous online articles on LinkedIn, arguments amongst lawyers, depending on whether you act for the landlord or tenant. I'm aware that when we first went into lockdown, some of these large chain stores that operate in malls sent blanket letters to their landlords saying, we're paying 0% because we can't use our premises. The background to that particular clause arose out of the Canterbury earthquakes, because prior to that, there was no relaxation of the rent obligation where you couldn't access your premises. And in Christchurch, many businesses, they weren't actually damaged, but they'd been red zoned.
Yes.
So that put a lot of people under. So as a response to that situation, we got in the 2012 version of the ADLS, that's the Auckland District Law Society lease, this clause that basically said that if the tenant was unable to fully operate from his premises, there would be a fair reduction in the rent and the OPEX. Now, some of the arguments I've seen from landlords is saying, well, you know, you've got an online presence, your customers are still able to purchase items, and you know, you can still supply them. But the response I've made for a couple of tenants on that behalf is, well, the landlord didn't pay for the website and didn't pay for the phone lines and didn't pay for the marketing of that. What we pay for is the premises. We're currently unable to get into those premises.
Right.
So by and large, most landlords I've come across have been reasonably realistic once we send a relatively firm email and also point out, well, if you kick this tenant out, you know, who's taking their place?
Not to mention, Kalev, have you worked out how you're going to kick this tenant out? Have you determined how you're going to actually serve Property Law Act notices? Because they have to be personally served.
Yes, that's right, Bruce. And we've already seen that. We mentioned earlier that 10 working day period under a lease has now been extended to 30 working days. So when we were first dealing with these issues, we didn't have that indication. But as we get into level 2, it's going to be more complicated because we were talking offline earlier, Bruce, that if you, again, in that high-rise example, if you can only go up in the lift, you know, 2 at a time, and you've got 60 staff working on the 35th floor, you know, getting your workforce in there is going to be difficult. So there's more complicated arguments there about what is an appropriate level of rent. Now, if you do fall into dispute, these leases typically say, and just remember, not all leases have this clause. There's a property council lease that's similar, but a lot of people are on the old lease. So
if they're exercising old rights of renewal going back 50 years.
Yeah. So again, you can talk to a lawyer about it, and paid lawyers, they're always happy to argue backwards and forwards while the clients pay. But you know, my advice is that you spell out, and what I've been spelling out to landlords who have been acting for a tenant is, okay, well, you can take it to court, but it's not going to get you your money. But also for tenants, you know, the flip side is, look, let's say you're a warehouse. You're not really that affected. You might have a stock turn of 25% per month, so maybe only a 25% reduction is relevant. But if you're a retail outlet, it is more difficult, but it's still better to have your stock housed and weathertight as opposed to off the street. So there is an inherent value there. So people need to be sensible. I mean, the lawyers, you know, we can talk about what the legal position is, but you know, we need to also look at business practicalities.
Yeah, and I'm sure you're going to have your game. You'll have your gamers, and then you'll have those that are genuinely in need. So it's just weeding through them. So right. Well, perhaps just to close off, just the opportunity for either of you to raise any other comments that sort of come along with these commercial matters or insolvency issues with COVID-19.
One that I've spotted, and Kalev, you may have a view on this, the legal view is always opaque, is the right to cancel contracts that you entered into. Forget property for the moment, although it could be a construction contract, it could be the letting of a subcontract on a construction contract, it could be an agreement to lease, it could be a lease, it could be all sorts of things. Most such contracts have a force majeure clause, which is usually intended to deal with there's been such an event that the ability of the parties to substantially perform the contract has been exterminated. Right?
Mm.
So I'm beginning to see commercial issues arising where people are seeking to triage their obligations to shore up their core. Right? And part of that is endeavouring to cut off the peripheral things that you may have been doing in your business and seeking to cancel existing contracts.
Mm-hmm.
And many are trying to rely on our contract is no longer capable of performance type clauses.
Yeah.
And that is becoming an increasingly difficult area.
Yes. Well, just to comment briefly from a legal perspective on that, the situation you've described are the force majeure or act of God clauses. Now, it's going to be easier to rely on a clause like that where it's a short-term contract, such as, there was going to be a music concert on this particular day. Now, that type of argument is going to be easier to make. But by contrast, if we go back to the leases example, the lease may be for 6 years. So if we're in lockdown for a couple of months, I don't think that you can say that the whole purpose of the contract has been destroyed. I've been contacted a couple of times by people with gym memberships saying, I don't want to go back to the gym, even at level 2.
Yeah.
What can I do? Now, there's no force majeure or act of God clauses typically in those types of contracts, but there is a common law doctrine. So when I say common law, I'm talking about judge-made law. Judge-made law over the cases. There's a thing called Doctrine of Frustration. Now, typically, that type of, the Doctrine of Frustration is something that you learn at law school. And, in life as a litigator up until now, that was very much a Cinderella topic that you would never pull out. If you had a really terrible case, you might think, oh, can we argue that? And you go, yeah, no, we'll look like dicks in front of the court. But these days, Doctrine of Frustration is something that we're looking at seriously. This thing actually might work. So, it's crap, for the economy, but for lawyers or people with the love of the law, intellectually, it's a fascinating time.
So take a real example that is big enough to litigate. You've designed and let the contract to build a hotel. Okay? You haven't started yet, right? But you've let the contract. You go to the building contractor and say, not much point building this baby. Let's cancel the contract. Builder loses forward work, doesn't want to lose the building contract. And you sure as hell don't want to build the hotel. I'm with you. I don't think force majeure or act of God works, but I do think the economic circumstances possibly give a strong argument for frustration.
Yeah, and just remember that litigation is a leverage tool. So you may file your claim, because my view is until you sue or there's a little bit of blood on the floor, people don't take you seriously in negotiation. So, no lawyer is going to give you a cast iron 100%.
No.
Yeah, we're going to win on this frustration argument, but it's a runner. Now, pre this pandemic, frustration wasn't really a runner, but it is sufficient in my view, in the right case, perhaps the type of scenario you've talked about, Bruce, that it would be a runner. And one of the probably the in that instance, the hotel developer would say, no, I'm cancelling it, and if you want to sue, go ahead. And in that case, the hotel developer would be the defendant. Now, it's always easier to be a defendant. It's the plaintiff that has to make the running in the case. So, yeah, frustration may come into that. No one really wants to go through litigation right through to a trial, but it would be worth, I think, having some proceedings issued rather than sitting there and trying to negotiate it. Again, I'm not a mediator. I've been a litigator for 30 years, so I run to conflict.
Yeah, it's always important to know what the battlefield looks like if you have to go into conflict. But the way I've approached this now in 3 quite major projects, Kalev, is to say to the developer, would you buy this building today for your forward cost profile? If it was finished, would you buy it today for the money you've got outstanding to complete or commence this piece of work? And if the answer's no, I'll say, well, then we are going to cancel, no matter what. There will be fallout and consequences.
Yeah.
For which there will be an outcome eventually.
Mm.
I'll bet my bottom dollar today that your counterparty would really value a check. This is your best time to settle it.
Yeah.
So if your net present value or value of your project is 5 million and it costs you 8 million to build it, you're not going to do it, right?
Mm-hmm.
If you can take 5 million off the table and pay 500K to the guy not to build it, you're better off.
And he may be too.
And he may be too.
Oh, sure.
So these times are a time when you have to restructure your business and your obligations. Sometimes alternative thinking around, what if I didn't do it? What would I pay not to do this?
Mm.
Which is counterintuitive thinking. But counterintuitive thinking, or thinking the opposite, is sometimes an easy way to get an outcome where everyone gets something they need so that we all keep walking.
Absolutely.
Right, I think we'll bring it to a close there. So thank you to you both for your time today. Now, if anyone out there has got a question for either Kalev or for Bruce, if you'd like to email Lisa, our marketing guru, Lisa at Gilshep, GILSHEP.co.nz, and just pass on your questions to her, and I'm sure she'll direct them to the appropriate person. So that's all from us today, and have a good afternoon. Thank you.
All right. Bye all. Thank you.